that is heightened, which is more heightened than in everyday normal cases, if I can put it that way, because we do have a former president that has a very checkered interaction with the law over the past couple of years. And we've now come to a point where this trial is looking like it'll proceed in the next couple of months. And the NPA really has to show us as South Africans that they can actually bring the former president to book and basically uncover the truth around this racketeering and corruption that is alleged to have been undertaken around the arms deal.
Yeah, and it has been a long-standing case, Benedict Phiri, and as you and I talk, I can hear sounds in my ear. I think it's inside the Pietermaritzburg High Court, so as soon as that trial does indeed start, we are going to take you there, but for the time being, let's continue the conversation here with Benedict Phiri. Benedict, of course, the former president faces another issue, and that is separate from what the courts are going to be sitting with today, which is trying to come to an agreement around a trial date for the corruption trial around the arms deal. There is the element around the State Capture Commission of Inquiry. I read the affidavit of the Commission Secretary, and that affidavit, I could not believe just some of the language crouched in it. But the important thing here is that the Secretary of the Commission is very clear that if the highest court in the land, which the former president has spoken up against, and some of its members, case in point, the Deputy Chief Justice Raymond Zondo, if that court does not assert its authority, then in pure language, it's going to be a free-for-all, where they say the rule of law doesn't exist. How important is this application for contempt of court?
It is critical, Toli. I think you've hit the nail on the head, because contempt, as you saw in the affidavit, is really aimed at the court vindicating its honor and taking its honor back. You know, courts have a moral authority. They don't have a constituency. They don't have voters that vote them in. And
in fact, those are the words exactly that the Secretary uses, that all that the courts have is integrity and that the public has confidence in the work that they do.
That's right. And I mean, in this instance, what you have is a former president who has the ability to speak out and protect those institutions. But instead, what is happening in a very public way is a constant denigration of those institutions, including the highest court in the land and certain judges, including the Deputy Chief Justice himself, without the ability to have a constituency to back you up. What other way can a court retain its moral authority except to assert itself, in this instance, through the granting of that contempt of court application, which philosophically, that's what it's actually meant to do.
Then there are two respondents. If we just focus the attention on the application by the State Capture Commission for Inquiry to find the former president guilty of contempt of court, which is what they're asking the Constitutional Court to do. The two respondents there are first the Minister of Police, then his Commissioner, Khehla Sitole. And there is the element where they talk about if these two respondents decide that they're going to challenge this, then that might be a separate matter altogether. Perhaps let's start there. Would the Minister of Police object to him being instructed by, would he perhaps want to challenge this court order that they be the ones effectively who effect arrest against the president? What reason could there be?
I think, you know, there is a legal question around whether the police commissioner and the Minister of Police are actually meant to be in this application to begin with. Because I looked at the affidavit and there isn't reference to why they are in the affidavit except for the reason that they should be effecting the order. But we don't have the usual sort of allegations that you'd expect to see when you incorporate a respondent into an application. I maybe have a fear that they might not effect the order if I get the order. Maybe there's something that happened at Nkandla maybe because, you know, the Minister of Police was there. That's creating some suspicion around whether, you know, I can take this constitutional contempt order and give it to the minister and he will execute on it, right? So that is a one piece that did not come through in the application, and I expect that on the arguing of the matter, it will be traversed because there is a question around why should the minister and the commissioner of police be ordered to effect that? Is there a reason why we believe that, you know, with the commission having that order and giving it to the commissioner and the minister, it won't be effected? You know, we don't see that coming through in the application. So that I'm expecting to see that on argument.
Back to the matter at hand, and that's the case before the Pietermaritzburg High Court. A trial date expected to be set today. Let's talk about the over 700 counts that the former president faces. The importance between charges and the counts. Set that out for us.
Yeah, I mean, it's at the end of the day, you know, what we are looking at is a series of actions that feed into a series of crimes, right? And I think that's really where we're going at. The counts and the charges speak to that design.
Yeah, and because people have almost confused this to say the former president is facing 783 charges. No, it's counts. That means that if it's payments, which is what is claimed he had received from the French arms company Thales, then it would have been the amount of times that he would have received these payments into his account. And importantly, this is what the NPA is going to have to prove before the court.
That's right. They are going to have to prove each instance that a crime was committed. And, you know, within the broader context of the racketeering or the corruption. So what they're saying is we have a corrupt activity or a corrupt course of conduct by the president, which is buttressed by each of these instances. And they're going to have to prove that. You know, they don't have to prove all 700 of them to get a conviction. It just means that there are 700 instances where we can point to indicate this corrupt activity, this racketeering and money laundering.
Money laundering and racketeering. The racketeering charge, Thales has been in court trying to fend off this particular charge of racketeering. They lost. What is a racketeering charge? In simple language, if you can, reduce it to a language that you and I can understand.
Right. So it's not very different from money laundering, if we can put it that way, clearly.
So the two are similar? The
two are similar, effectively, in the sense, you know, that we are disguising the proceeds of monies and where they actually come and they actually go, you know. So that's the most simplified form that I can put it for you. Yes.
Sure. All right, Benedict Phiri, for the time being, I think we are going to see if we can take a short breather. When we return, we are going to continue the conversation. All right, I'm told that there isn't a break that we need to take at this time. Perhaps let's soldier on then. And let's talk about the former president, Ulrich Roux, saying that if indeed the legal woes that surround the former president right now, if any of them does stick, whether it be the contempt charge, if it is what the Constitutional Court ultimately finds, which is separate from this matter that is today, the former president might lose his privileges as a former head of state. Is that something that indeed is provided for in law? Because there is the other argument that even if he is convicted of a crime, the privileges of being a former president are intact. It's quite confusing.
It is. I think there definitely is space for the legislature to wade into this, because the way that the constitutional provisions currently work is that, you know, the former president would have to be impeached for him to lose his privileges. And in this instance, you know, that's not, you can't get there because he's already a former president. So there's definitely a space for Parliament to actually then wade into this from a policy perspective to say, well, we have a scenario like this that has now befallen us, and in the future, how would we want to deal with it? So I believe that the question around the former president losing his privileges will actually be driven by Parliament and not necessarily be an automatic event that follows his contempt or conviction.
So right now, as things stand, the law is basically almost, there isn't a law that provides that if a former president is convicted of a crime, he loses his privileges. So the law is almost silent on this matter. Is that effectively where we are right now?
That's my understanding. That is my understanding, that effectively, at least from a contempt perspective, that would be something that doesn't necessarily lead the president to lose his privileges. That is my understanding.
Sure. Then, Benedict, there is, of course, the other element that the country worries about, and that is a potential constitutional crisis that we might have as a country. Here's a former president who, in a sense, the Commission of Inquiry argues he has been contemptuous of the most highest court in the land, refusing to obey its instructions. There are legal processes underway around that matter. Then you have people who have stationed themselves outside the former president's home. And they are very clear that whoever wants to come and arrest the former president is going to have to go through us. And to prove that, they did stop a whole police minister for checks. I don't know what checks were being conducted, but eventually he was able to go inside the compound. Could we face a potential constitutional crisis here if the former president has to be arrested and law enforcement is trying to effect an arrest and there are people who are stationed outside saying no?
The constitutional crisis would occur where the law could no longer deal with this matter. And I think for a few moments we've gone there where we've thought, well, we're not sure what's going to happen next, Certainly if there is an ability on the part of the Minister of Police and the Commissioner of Police to effect an arrest pursuant to the contempt order, then we don't have a constitutional crisis, because what it means is that the machinery of the law has actually absolutely been effective in that moment, right? It might not have been efficient, it might have taken us a long time, but ultimately the law trumped over the interests of an individual. If we do continue seeing a situation where the interests of an individual are seen to be above and superior to the law, and the law cannot wade into that space and deal with it decisively, then we are going towards a constitutional crisis.
Sure. All right, Benedict Phiri, let's park our conversation there for the moment, and let me tell the viewers that we are waiting for the proceedings at the Pietermaritzburg High Court to start at any moment, and when that happens, we are certainly going to take you to the courts